Okay, let's get started. Om Namo Narayanaya. Hello, everybody. Welcome to the Guruvayurappan Temple of Brampton. Let's start with an invocation prayer. So, Om Sahana Bhavatu Sahano Bhunattu Sahaviryam Karavavahe Tejasvinavati Ma Vidvishavahe. Om Shanti Shanti Shanti. So my name is Rudra and I will be emceeing the seminar today. Before we get into a bit about our speakers, I just wanted to let everybody know, in case you may not, that the temple that is located in Brampton, Ontario is open for devotees. So we encourage everybody to come visit our beautiful temple. So pujas and rituals at the temple are being performed as usual, and devotees may book pujas and visit our temple. So please check our website for guidelines, and our website is guruvayur.ca. And devotees can seek advice from Thirumenis by calling or emailing the temple. And if you look at the slides, you can see our email and telephone number listed. So, as well as our phone numbers on the slide as well. So GTOB conducts frequent panels and sessions on religious topics, as well as panels of general interest. And today, we have a panel with our two wonderful speakers, Lata, Menon, and Darrel. Today is the first of our two-part seminar, and today's topic is estate planning. And on Saturday, March 26th, Lata ji and Mr. Paul will be conducting a seminar on wills and trusts for GTOB. Now, a bit about our speakers. So Lata ji is the founder of Menon Law Professional Corporation, and she received her master's degree in sociology from Mumbai University and her LLB, her law degree, from Mumbai University in 1996. She practiced for many years in India, in 3 states in India in particular, and worked for many prestigious firms. In 2006, Lata ji was called to the Ontario Bar and is a member of the Law Society of Ontario, the Peel Law Association, and the Ontario Bar Association. Her areas of specialty are civil litigation, family law, and criminal law. Lata ji has successfully argued before the Ontario Court of Appeal and Superior Court, and she is the director of Menon Law Professional Corporation, which is a full-service law firm. Our other incredible speaker is Mr. Darrel Paul. Mr. Paul is from India, where he practiced law within the areas of civil litigation, motor vehicle accident claims, bank recovery suits, and many more. He immigrated to Canada in the year 2003, where he worked in a law firm as a law clerk while studying for his accreditation exams. Mr. Paul was called to the bar in 2008, and his areas of expertise, to name a few, are civil litigation, wills and estates, and small claims court cases. He joined Menon Law Professional Corporation in 2013, where he works alongside Lata ji. Lata ji, Mr. Paul, thank you for taking the time to speak with us today. I'm sure that all of us are very eager to learn from you both and learn more about estate planning. So before we kick this seminar off, I just want to remind everybody to please keep your mics muted. And we will be having a Q&A session at the end. So please send your questions through the chat box to me, and I will read out your questions to Lata ji and Mr. Paul. So without further ado, Lata ji, Mr. Paul, please take it away.
Namaskaram, and thank you so much, Rudra, for your wonderful introduction. And I will go forward. I don't want to, we have very little time, so I wanted to go forward with it as soon as possible. But before that, I just wanted to thank the president of the GTOB for giving us this opportunity, and all the board of directors to thank you so much. And also our Shaji Krishnan, when he, called me and he said that we wanted such a session for, all the people here, and we would wanted you to, and I readily accepted that, and thank you so much for giving us this opportunity so that it could be helpful to many people who are there today, to the listeners. And I also want to thank all the people who have been listening today, and for spending their time and to come over for a long weekend, even though it is, to come to this wonderful session. So thank you so much. And I also wanted to thank my associate colleague Darrel Paul also, who's here today. And he found his time over here. I know he's far away here. I know he's in Belleville, but in fact, still found out time to come in this morning to spend with you all, and to give this wonderful information. I hope it'll be informative to you all. And so let's begin with it. So now what we did is we tried to split that. Let me put my speaker so it'll be more audible. So what I wanted to tell you, before that, I hope everybody heard, or else I just wanted to thank the president, and I wanted to also thank all the board of directors and Shaji Krishnan. And because that time I think I didn't put my speaker, sorry for that. But anyway, so let me begin with it without much of time, because it was very time constrained on it. Now, estate planning, today we have a wonderful topic and a session on estate planning. So we all want to know, what is this estate planning? What is this all about? So estate planning in Canada follows many of the same rules and conventions as an estate planning in any other countries. Now, why do we do estate planning? What are the two goals important for an estate planning? One of them is to distribute your assets. How you distribute your assets according to your desires, and how you minimize your tax in a way that goes against your wishes or your principles. So sometimes there are tax complications which can come to an implications, which I'm not going to talk in this sessions. It will be our next sessions we'll be looking into, but I just wanted to, these are our goals, how you minimize your tax and how you distribute your assets according to your wishes. Now, estate planning involves creating. When we hear a word called estate planning, everybody will be wondering, what is this estate planning? Now, estate planning is creating a set of instructions that details how your assets have to be used and distributed in the event your death or incapacitation. So your estate plan will be composed of several parts of the legal documents and financial tools, so that you can put all this together into your particular documents over there, which will be a legal binding document, and it will be a power of attorney or a living will, or it includes an insurance policy or a financial arrangement details. So all this a set of instructions which we are putting together in a legal binding document, that becomes your will, where your desires are being put, how you want to distribute your assets, how do you want to do it. Now, there are specific assets, some things the questions we always ask to ourselves when we make our estate planning. What do? And we ask them is, are these specific assets you want to give to a specific family member, or at what point do you want your family members and loved ones to receive the specific assets? എപ്പോഴാണ് നമ്മൾ ഇത് കൊടുക്കേണ്ടത്? എപ്പോഴാണ് നമ്മൾ മരിക്കുന്ന മുമ്പിൽ നമ്മൾ ആർക്കെല്ലാം ആണ് കൊടുക്കേണ്ടത്? നമ്മളുടെ കുട്ടികൾക്കാണോ, നമ്മളുടെ സഹോദരിക്കാണോ, നമ്മളെ ചാരിറ്റിക്ക് കൊടുക്കണോ എന്ന് നമ്മൾ ചിന്തിക്കും. we start thinking about it, and then we will say, no, now I will have to put all this together. And then we will say, after your death, during your lifetime, so we will be thinking is, when should I give these assets? എപ്പോഴാണ് ഞാൻ ഇത് കൊടുക്കേണ്ടത്? ഇന്റെ സ്വത്ത്, ഞാൻ അധ്വാനിച്ച ഇത്രയും എൻ്റെ ബാങ്ക് അക്കൗണ്ട്സോ in the properties എവിടെയും എല്ലാ കൺട്രീസിൽ എവിടെയെല്ലാം ഇരിക്കുമ്പോൾ, we will be thinking that in what point of time are we going to give this assets, during our lifetime or at a specific time or during our death. And then the next question which leaves into is, are we giving this to our estate, to our charity too? If so, which one are we ready to give it to? And how important is it to minimize the income tax and the probate fees? And then we also think about it, saying that, do you have a life insurance policy to cover this anticipated capital gain tax that will arise after your death, and protect your businesses against the losses? And if you own one, if at all you have a business of your own, then we will be thinking that, how do we have to save those taxes? How do we save the capital gain tax? So these are the things which can come in your mind when you start making a will, or when you start making some of the documents which you intend to tell your lawyer that this is what I want to do it, then you also will also think is, how do I transfer, to whom do you want to transfer the registered assets like the RRIFs or RRSPs, and these accounts, whether it is depending on your beneficiaries, or how do you want your property to remain in the hands of the people, and who has to take care about this, who is going to take care of them, and how are they going to distribute this money, and how it can save your loved ones from the time and money managing your estate and dividing your assets. These are the things which we have to think about it, what we are going to leave to our near and dear ones. Usually when we think about estate planning, it is our wishes, it is our desire. We have been accumulated and we have worked hard all through our life at one point of the time. It's not that you say, some people I've seen that when they come to the office, they say, oh, will, I've never thought about it. I never thought that I should make a will now because I'm too young now. It's not the question of young or it's not the question of old. It's the question is that how soon you make the will and to whom you have to give it. Because the reason is we never know the life. As we learned from the COVID pandemic, it has taught us many things now. It has taught that the life is very short. Of course, we also knew this earlier also, that the life is very short. But it became more prominent now after this pandemic, that people started getting, really worried about as to, oh my God, what is going to happen to me? The very next moment or the very next second, what is going to happen? The life is so very, we cannot know when it is, what is going to happen. And are we going to leave all these so that our loved ones do not suffer that? Now, we just had recently something in our office where the closing is going to take place in next month, but that person is not left a will, not even left a power of attorney. He's already in the ventilator now. Now, we really do not know what the family members are really troubled. They do not know. They have 5 children and all of them are running around to see what has to be done. And because that's going to be a huge loss to not only to the person where it's going to be, because it's going to be really creating trouble at the time of the closing. So then the question comes is, then we'll have to bring something into the court, we'll have to bring an emotion, we'll have to, so many things are coming in. All this is causing what? A panicky among the family members, panicky among the ones, even the lawyers have to see what has to be done, how this has to be done, because the person who's going to buy the property has already sold the property. They don't have any place to move around. Then what happens? So, these things, and the person is already 80 years old who never thought to make a will. It is a document which he should have made, or a power of attorney to give it to somebody, at least anything. And he was hale and hearty. That person was not a sick person. He was actually here totally, he was fit and fine, and all of a sudden he went into he got a major heart attack, then he had a heart surgery, and then he couldn't recover. He's on a ventilator now. So these are the things which we have to look into and I think my colleague will go forward with more of specific things and what are the things to be made. But I will only wanted to say the bottom line to creating an estate plan is to make a valid will, is to make how you make your transition from this world to the next easier for both yourself and your loved ones. You will have a peace of mind knowing that you have put a plan in place, and your loved ones, and for your loved ones, of course, your loved ones will definitely appreciate your willingness to think ahead on their behalf. So I would wanted to stop here at this point, and I would like my colleague to continue with it. Thank you so much.
Hello? Hello?
Yes, we can hear you, Darrel.
Yeah. Good morning, everyone. Good morning, Rudra, and thank you very much for that great introduction and for the compliments that you have given to Lata and to me. And we are very happy to be with all of you all this morning to speak about this very important topic about estate planning and wills, etc. And I'm sure that there will be a number of people who will have so many questions, And I do not know how many we can answer, because that was our experience of the last time we had such a seminar. I would like to just briefly talk about the importance of making a will. All of you will agree with me that all through our life, and especially our work life, we slog, we labor, we struggle in order to build up some assets. And then to think that at the end of our lives, our assets will get dissipated, will not be used the way we would like them to be used, or to think that we are not making provision for our loved ones, our spouse, our children. These are the people for whom we have slogged so much over so many years. And it is this act of making a will that will set down your desires, your determination as to who should get what part of your asset. All this is something that is very, very important. And it's all of us know that we have to make wills. Nobody who is listening to us today will say, oh, I am exempted from making a will. I don't need to make a will. No, all of us know we have to do it. But the only problem is that we keep postponing it. We, we do not get down to actually making our will. I'll just give you a small example from my experience. Somebody came to me and said that she wants to make her will. I said, okay. So I spoke to them, got all their details, their desires, their determinations, drafted the wills and sent it to them. And after that, I didn't hear from them for 1 year. Then after 1 year, suddenly I get a frantic phone call from this lady. She says, you know, Mr. Paul, I have to meet you. I have to make my will. Then I said, what happened? She says, last week I became so ill, I was rushed to the emergency. And I am grateful that I came out alive. No, I have to make my will. Now that lady was lucky. Ultimately, she came and made her will, etc., etc. But all of us can't expect to have the same kind of luck. We might fall ill at any time, and we may not return from the emergency. We may not return from the ICU. So that is why we have to make provisions for all these contingencies. And we have so many opportunities which are afforded to us where we can get down to making our wills. It's just a question of sitting down and saying, yes, I want to do this, and then it can be done. Now, in the making of your will, what you are doing is you are going to designate the disposition of your assets. You're going to name somebody as a trustee and executor and entrust your estate to that person and say, my estate has to be distributed in this manner. Now, this is very, very important for all of us, and very especially important for those who have minor children. If you have little ones, how do you ensure that they are going to be looked after? What if you and your spouse are traveling somewhere together? God forbid it happens. Say in an airplane and the plane goes down. These things are not uncommon. Who will look after your children, especially your minor children? You owe it to your children to make this determination, this provision for them to be looked after when you have passed from this world. This is something that is tremendously important. It's a duty on all of us to make sure that we make provision for our children. It's not enough that we provide them with all their necessities only while we are alive. We also have to meet this contingency of us not being around at some time in their lives. And then what's going to happen? None of us would be happy to imagine that our children are left without a will, without any determination about the property, and they keep complaining and saying, what did my father do? What did my mother do? Why couldn't they settle all their properties instead of leaving all this mess for us to settle? And let me tell you, litigation is bad. Yes, litigation is bad. None of us wants to get into litigation. And estate litigation is the worst kind of litigation that you can be involved, not you can be involved in, anyone can be involved in. And why is it so bad? It is bad because your estate is being disputed and you are not around to tell the court or to tell anyone what you would have done if you were living. And it is for that very reason that you make your will, so that there is a proper determination of the distribution of your assets. Now, as Lata already mentioned, I don't want to repeat what Lata said about the importance of making a will and the importance of estate planning. Because for your estate, you've got so many duties which are applicable. You got estate duties, then you've got income tax, and then you've got capital gains. So many duties that are applicable, and to a great extent, if you apply your mind to it, you can make sure that your beneficiaries are not going to be unnecessarily burdened with paying taxes on your estate. It's for that reason that you would think of estate planning as something that you're going to do for your children and your beneficiaries, and that is your act of love for them. You are making your will out of love for your loved ones. That is the bottom line about making a will. You're not doing it for any stranger, but for your own loved ones. And that's why I urge everyone who is listening today, please get down to doing this. And when should you make your will? Well, as Lata said, life is so uncertain. They say that in Canada, there are only two things which are certain. One thing is death, another thing is taxes. These are the only two certainties we have in this country. So we have got to somehow dodge the bullet and be prepared for this and make sure that our beneficiaries are not adversely affected. Thank you very much. And I would be happy to welcome questions from all our listeners. Thank you very much.
And I also wanted to say that we're not only talking about the will, but we're also talking about the power of attorney, which is called the living will. Now, I would like Mr. Paul to, say something about the living wills and why these are important too, because I know that was a part of it. So if you could just tell them briefly about it. Thank you.
Okay. Now, all of you all realize that when you make a will is a document that becomes valid from on the day when you pass away, that is after you die. Now, today, all of you who are listening are awake, competent, conscious. You can make your own decisions. So what happens between the in-between time from today and the day you pass away? Supposing you are in a coma, then who will make decisions for you? Supposing you are in a coma from where you are going to be there for a long time. Who will look after your property? Who will manage your bank accounts? All these are questions that we have to answer. And in Canada, the government has provided a very convenient act called the Substitute Decisions Act, where you can appoint someone to look after you, to make decisions for you under these circumstances. When you are in a coma, when you are not competent, when you are disabled, they can make decisions for you and look after you and look after your properties. There are two kinds of documents that we prepare. One is called general power of attorney for personal care, where the person who is authorized by you when you are still conscious is empowered to make decisions for you and give instructions to your treating doctors when you are in the hospital in an ICU. That's called GPA for personal care. And there's another GPA called continuing power of attorney for property. And this power of attorney will empower your attorney to make decisions on your behalf in respect of your property, so that you can be looked after, especially when you are in this condition, especially at that time, to make this continuing power of attorney for property. Now, these are called living wills. These two powers of attorney that we make are called living wills. And once you have made this full package of GPA for personal care, continuing power of attorney for property, and your will, you have a full package where you have looked after any contingency that may arise, which would affect you and affect your assets and affect your loved ones. So that is the package that we offer you of these three documents. Thank you.
And another thing which is very important is in the will, when we make, who are the executors and who are the beneficiaries. These are the two things which we have to look into, because there are many questions and many people do not know who is an executor and who is a beneficiary. If you can throw some light onto it.
Yeah. Whenever people approach me to make a will, I ask them a few questions. So I say that you're spouses, yes. You have children, yes. Are there minors? Are you? Yeah, if they say yes, okay, you got minor children, or you got children who are not minors. That's also fine. Now, I say you are going to make a will where one spouse will be leaving all that he dies possessed of to the other spouse, and that spouse will leave all that she dies possessed of to him. So far, so good. Then I say, just imagine this scenario. Suppose both of you spouses are in an aeroplane and something happens, God forbid, something happens and both of you all perish together. Then who will look after your children? And when I pose this question, there is a long period of silence. They will be looking at one another and saying, well, we have not yet decided on this. We'll have to talk and discuss and then come back to you. And I say, it's fine, perfectly fine. Perfectly fine. Because as long as you have father and mother, the children have got a natural guardian and they will be looked after. What happens when both of them perish? They'll have to appoint somebody else to look after the minor children, appoint them as a legal guardian, make them an executor, a substitute executor, and also legal guardian, so that the minor children are looked after. And whenever I draft a will, in our office, whenever we draft a will, we always say that the executor will take charge of the estate and provide for the infants until they reach the age of 23. And then someone asked me, he says, why 23? At 18, they are adults. I said, yes. Just imagine, you give an estate worth $1 million into the hands of a child who is 18 years old. What do you expect that child to do with that estate? Does that child have the maturity to manage an estate of $1 million? You don't want your estate to be wasted. And that is why we always put at least till they are 23, where they would have had some experience in life, they would have had some maturity, and the estate can be then transferred to them. So that is an additional provision which the parents are making to look after their children and make sure that they have someone there to help them, advise them, guide them, and make sure that their estate is properly used. The estate trustee will be authorized to keep the shares of the children, minor children, in separate accounts and use money from there for their educational and maintenance expenses. In that way, you are also providing for your children's care, for their education, etc. Just as you would have done if you were alive. So that these are all the provisions that we can make for our children in our will. Thank you.
So that's what I wanted to tell all of them, the listeners here, that's when we make a living will, it's more like an operational control. You're giving a control from you to the next generation or to the next person whom you're mentioning as your personal representatives in your for your power of attorney for your property, where they can take care of your day-to-day activities, your bank, how they have to operate a bank, and how they have to they have to pay the bills. All these are the operational control which you are passing on to the to the other person who can take care when you're incapacitated, or as my colleague mentioned, is that you're in coma, or that means you don't have to die, you're in that position for a certain period of time. It's your decision, your desires, how you want to operate the accounts, what are the things which you want to pay, what are the things you have to give in, because tomorrow when you are in the hospital, you never know in what stage you are. As Mr. Paul has already said, my colleague, saying that if you meet with an accident, we all go out in the morning, we do not know till we return back home what's going to happen. But as we said, anything could be happen to us, and how do we look into it, and how do we able to make the other people take care of your bank properties or your bank assets or your bank accounts, and you have to pay all these bills, you have to pay through your pensions, you need to have the money coming in, flowing in. All this will be given through that power will go, or your rights will go from that power of attorney, that will flow through it. I think most of them do not know that. I mean, for example, when they make, why do you make a power of attorney for personal care? They always ask us, why do we need that? You do not know that document is such an important document. I remember those days where we had to rush to the hospital in the middle of the night when people call you, say, you know what, we don't have this document, can you please come and make to us? So so many people do not know what is the the seriousness of that document. That document is the where you have to look into it, that for example, you're a husband and wife. The husband will say, I have every right to talk about my wife. I would want to know what treatment she's getting, who is the doctor attending to her, whether she could get a better facilities in the different countries, can I take her to a different place? All this can be done only through a power of attorney for a personal care too, because the personal care is a very, very important, because your rights flow into it. Only when you have that document and a photocopy is given to the hospital, whoever is going into the hospital or getting admitted, is whether it is for the wife or whether it is for the husband, this document is very, very important, because from there your rights flow. With this document, the doctors will talk to you directly and tell you that what kind of treatments are going on, and what is he suffering, and what is it, a terminal ill sickness, and how long he can survive. Because I have seen many of the patients or many of my customers or clients who come later on, when I meet them in the hospital, I can see literally the tears coming out of their eyes. I do agree that what doctors will have to do their work. I'm not saying about that. What I'm trying to say is, you don't want to listen. We all, life is very uncertain. We all know at certain point of the time we have to go, but you don't want to listen that from a doctor's mouth and say you have only 1 week to live and you have only 3 days to live. Of course, that is a terrible part for us to it. But instead of that, our family members can hear that and they know what to do. That's what most of the things most of the people say that. So that, what I'm trying to say is the power of attorney for personal care is a very important document, and in that should be, you should have those documents with you. Because some of them, they come to us and say, why should I have those documents? I can have only a will, that is more than enough. So what we say, no, you have to make a living will, because it's very, very important. As my colleague rightly said, when you're incapacitated or not able to do during a certain part of the time, you need this document to get operated. And of course, we have to, when we make a will as simple as possible. And why we make it that? Because people have so many properties. They have properties in Canada, they have properties in India, they have properties all over the world. So they will say that why don't you list all these properties? So I and my colleague, we always say that we don't want to list all the properties as one schedule to the will. The reason being, and even jewelry, people say, oh, I have all these jewelries, why don't you list it all this? What we are trying to say is to make it as simple as possible, because when your loved ones in the after your when something happens to you and after your death, then when this becomes a part of your estate, so all the properties which are in existence, let me make it very clear, when it is in existence at that time will become a part of your estate. So you can buy, you can sell during your lifetime, you can do whatever you want. We don't have to list those properties names at all, but all those properties which are there in existence will become a part of your estate. And the same goes with jewelry, because sometimes you may sell this jewelry, or you may add additional jewelries to it. So why do we make it? We just make it as a part of the jewelries, and that will become a part of your estate at the time of your death. Is that correct, Darrel?
Yeah, the only thing is that jewelry is something that keeps changing, and you can deal with that without writing it down as part of the estate, because you'll have to pay estate duty on that. If you put down your jewelry as worth 300 or 400,000, your beneficiaries are going to be unnecessarily paying duty on that, on the jewelry. Whereas if you keep a list of the jewelry you have and how you want it to be distributed, your executor can take that list and distribute the jewelry according to your wishes. That does not need to be part of your probate. The executor can do that for you. So that is why we encourage our the clients to keep a schedule of their jewelry and how they want it to be distributed. What should go to which child or grandchild or anyone. Write it all down, keep it with your other documents, so that your executor can say these are her wishes, and this is how the jewelry is going to be distributed. That's it.
And then also about the immovable and movable properties. For example, the immovable properties, whether it is here or in India and everything, it will become a part of estate, but there is a procedure for it, that how you have to do it. Of course, that's going to be the next session, which we are going to, as Rudra has mentioned, for the next month. So we will leave it to that, where we can say how the properties and what we have to get a probate, and how do we get an estate certificate, and what are the procedures for it, what we have to follow it, and also what the estate duty which follows to it, and what should be added and what should not be added, and how you can save some of the tax liabilities. I hope so. We have covered most of our part in estate planning, and I leave it to Rudra now.
Thank you so much, Mr. Paul and Lata ji. That was wonderful. So we have a lot of questions that we can get through now. I ask that if anybody has any other questions, please send them to the Zoom chat box, either to the general chat, or you can send it to me personally. My name for the Zoom is Rudra Krishnan. So our first question is, there are options to create wills online. Is it okay to go with that option? What are the pros and cons of going through an online will software as opposed to going through a law firm?
I can take that question, Rudra, from my own experience. You see, if you go to Walmart for $99, they're giving you a package, a self-help package to make a will. And lots of people, they say, why go and spend money paying a lawyer? Let's do it like this. Do it yourself kit, you see. So there was this lady who went to Walmart, paid the money, got the kit, filled up whatever she wanted to fill up. And at the end of it all, she came to me and she said, look, I went to Walmart and got this and did all this. Now I am not sure if I've done the right thing. I said, okay, we leave that aside and let's make a proper will for you and get it properly executed and commissioned, so that you have peace of mind. You say, okay, I've been to someone who knows what I should do, who has done it the right way. And now I can sit back and say, okay, I have actually done my will, executed my will properly. So you go to an online site, you download something and do it yourself. Well, you still haven't answered that question to yourself. Have I done the right thing? Is this a valid document? That is the situation that you face if you want to go online and make your will.
And doing the right thing
Yeah.
is very important. Sorry, Lata ji, I'll let you answer this one as well.
No, I was saying is that what he's saying is absolutely right. I'm not telling you all to come to my law firm or anything like that. But what I'm saying is always better to have a professional help, because you're making a document, and that document, like for example, if I wanted to, get some medicines, and without even going to a doctor, I go to a compounder or a pharmacist and say, look here, this is what I got. For some things it's fine, but some things are better. I get a professional help. I rather go to a doctor and get a proper prescription done and then get it done, rather than this can be any, we never know what it can ultimately lead to, some of the drugs which I'm taking. The same goes. It's not that I'm saying that you'll have to come to the firm or to my firm. No, I never advise that. But what I'm trying to basically say is that it's better to get a professional help, because there are so many things, there are so many doubts in your mind which you would like to clarify in the aspects of tax liabilities, or in the cases of what are you wanted to do and how you want to go by and how you want to carry. So I always think is it's better to take a professional help, and that is more important. I know there is a lot of things in the website and many things are there, but internally many people do not know so many things, and they have lot of doubts, as my colleague said. Because for example, some of them, even the funeral, how you want to conduct your funeral, how you want your loved ones to, your wishes to be carried out, all that is being put it in the will. So there's certain things, and then we have to see which is the appropriate way to do. Some of them says, oh, you know what, I want to be carried to India and gone there, but there are so many there's so many hurdles when you do all these things. So it's better if you get a professional help, and that I think will be my best advice to everybody would be.
Thank you for your answers. So moving to the next question, which is somewhat related to this question. One person was inquiring, what is the average cost of completing the entire will package?
Yeah, Lata will answer that. Yeah.
That's a good question to ask, because what happens is all depends. There's no average cost or a minimum cost or how it is. It all depends on firm to firm. So if the person is so interested and if they wanted to go forward, they can give us a call to our office and we can let them know that what has to be done and how much is the cost going to be.
Great, perfect. So another question that we have is, I'm hearing a lot about insurance for capital gains tax. Can you tell us a bit more about what that is and which insurance companies sells these kinds of insurance?
I didn't get you that, Rudra. What was the question which you asked?
So can you tell us a little bit more about capital gains tax and if there's insurance for capital gains tax?
So what we are saying is Darrel, if you can answer, or is that being kept for the next session?
No, we
were
will keep
keeping
that for the next session. But a broad answer is that when you have an estate, you would like your entire estate to go to your kids and your beneficiaries. So you'll also tell them, look, I'm also going to make provision for any duties that you have to pay to be paid out of a particular policy that I have made. I have made a policy which will provide for the payment of those duties. That is what we mean by insurance, to cover capital gains tax and other duties. That again is the benevolence of the testator. Testator is the person making the will. His benevolence, where he has said, I have provided so much for my children, let me make an additional provision for them so that they can also pay the duties. This is another question someone is asking about, how much is estate duty?
And that's
Okay,
what we wanted to keep it for the next session. So we will
we'll
tell
keep
you
it for the next.
exactly how much is that, that's why we kept it as a trust and, the probate duties. So, I mean, because we were just made it into 2 sessions, and that session will be based only on those things. So which we can address it as to how much will be the estate duty based on what is your net equity of the property.
And just a reminder, and we hope to see everybody there, and we encourage everybody to attend. The second session is on Saturday, March 26th. So please mark your calendars. We have another amazing session with Lata ji and Mr. Paul. So another question that we have is, what is the difference between an estate trustee and an executor? Can you talk a bit about that?
Well, I can answer that. There is no difference between estate trustee and executor. And if you look at the drafts that we make, we use both the terms. We say estate trustee / executor, just in case there is any dispute about it, saying, oh, you are only a trustee, you are not an executor. We use both the terms. Both the terms are interchangeable, and that's why we put both those terms there: estate trustee and executor.
Okay, thank you. That definitely clears it up. So another question is, if you do not have extended family in Canada, can you authorize family in India to take care of your minor children and to execute a will?
It's a beautiful question. Yes.
That's a very practical question from whoever has sent it to us, because a large number of our listeners have their roots in India. You see, so normally what we say is, it all differs from case to case. As I told you, suppose you've got minor children here in Canada, and both the father and the mother perish together. Something happens, they die together. Who will look after these minor children? You want to appoint your brother who is in India, or your sister is in India, to be the estate trustee and the legal guardian of these minor children. But by the time they come from India to Canada, who will look after these little ones here in Canada? That is the question. And when I pose this question to my clients, they say, no, we have got to appoint some friend here who will agree to look after the children, even as a temporary substitute executor and trustee, until my brother comes from India to look after them. Okay, that is one possibility. Another possibility I came across is where someone said, I'm appointing my friends who are here as substitute legal guardians for my children until they are 23 years old. They will look after my estate, divided amongst the children, look after the children. And then he says that in the event my children decide that they want to return to India for good, in that event, I am appointing my aunt who is in India to be the legal guardian of my children until they are 23 and look after them. And then we also made a provision that the local trustees will take hold of the entire estate, dispose of it, and transfer the funds to India to look after the children there. So what I'm trying to say, the long and the short of it is that this is a real problem. We come across it very often, and there are ways of getting around it. Basically, you have to appoint somebody locally to look after your estate and your children until your relations from India can come here. Okay.
Thank you for your answer, Mr. Paul. I'm sure that was very, very helpful, and I know it's very informative. So another question that we had, and throughout the seminar, you both mentioned how important it is to create a will, to make a will. But at what age or life stage do you recommend someone create a will?
That's a beautiful question, Rudra. And I would like to get back to whoever is asking about this, saying, look here, So today is the 19th of February 2022, and all of us are here remotely connected to one another. Now you give me an assurance that tomorrow morning I will be alive to be able to communicate with anybody at all. You give me some assurance. I'll be very happy to get that. Can anyone do that? That is the question. The uncertainty of life is the problem that we are up against, and we are trying to see how best we can deal with this problem. So when you should make a will, answer is as soon as possible.
So as soon as possible, very, very succinct answer. And of course, like you mentioned, Mr. Paul, the only guaranteed two things are taxes and death. So as soon as possible is the right way to go.
Yeah.
Our next question is, other than not actually preparing a will, what is a common mistake you see people make with regard to estate planning?
Well, if you don't make a will, how is your estate going to be divided? Suppose you got whatever, 3 children, 4 children. How is the estate going to be divided? You want them to fight with one another? That is the question. You see, your son will say, according to our custom, everything goes to the son. The daughter, she received dowry for her wedding. She got her share of the estate. She's not entitled to anything. Now, all this does not hold good any longer. All this cannot be used in Canada. So you make a determination of who should get what. And if you cannot do it when you are living, don't expect your children to be able to settle amicably about your estate. Don't expect that. And as I said earlier, I'm saying it again, each of us has a duty to our loved ones to make sure that our assets are not dissipated and are put to the best use after we are gone. That's our duty.
Thank you for touching on that. Another question we have in the chat box that came quite recently is, can there or are there provisions in place to ensure that the executor is acting for the benefit of the beneficiaries?
Well, it's like this. In the will, you have to give the executors absolute discretion in making decisions. Because if it's a question of division, suppose your estate is divided into 3 parts, 4 parts, you will always have someone saying, she got more, I got less, or he got more, I got less. This is human nature. And that's why we say executor has absolute discretion. Nobody can argue with the executor when the executor makes a decision about partitions of properties. Now, at the same time, suppose the executor decides very much more in favor of one and not the others, and the others are deprived or prejudiced seriously, you always have the court where you can go and say, this is something that is astounding, where the executor has made this partition which would cause alarm to anyone, which would shake the conscience of anyone who looks at what the executor has done. It is so blatantly one-sided. Then the court will interfere and make sure that there is proper distribution. But for the greater part, if your executor is someone whom you know and it's based on trust, and this person is trustworthy, then your estate can be divided properly.
Yeah, which is very true, which I agree with Mr. Paul. So what happens is, I also wanted to say that if you don't have an estate plan that includes a will, then what happens is, then you will have to, the you'll have to go to the court and to appoint an administrator of an estate. And this administrator will then manage the estate and then makes important decisions about what happens to your assets. So it could be someone who has no regard. You can see, yeah, I'm very emphasizing on this, that it could be someone who has no regard for your desires or keepsake items. You know, when you have your own executors, which you would have mentioned in the will, they would have some regard to you, correct? They would have known you personally, they would have seen you everything. But if you keep a court administrator, because without a will, then he will have to distribute it to that which he will have no regard for what you have done it or what your desires are there. So this could, and he may have to sell the precious family heirlooms like jewelry or ancestral jewelries, or fail to minimize taxes, fees. These all could, the complications could arise if you don't have a proper executed will. And what I'm trying to say is, like you earlier, there was a question when people said, is it necessary to go to a lawyer to make a will? Like, I would like to say again, once again, about it. A will is very important, and how you are executing the will. The witnesses are who has no interest in the property or your assets will be the witnesses who will execute the will. So the witnesses plays a very important role too when you're making a will. Is that correct, Darrel?
Yeah, that is correct. And if I might just add one little sentence, and this is a word of caution to everyone. In estate litigation, the only people who profit are the lawyers. The beneficiaries are losers, and the lawyers are the ones who make money. So for heaven's sake, don't leave such a situation where your estate has to go into litigation. Please don't do that.
And also, when you have minor children, when you have got minor children, it's very, very important in an estate planning process that you should create a will, because if the children are minors, then you want to give explicit instructions to the court as to what would happen with your children should you expire before they reach the legal age of the responsibility. So if you fail to do this, then the court would have to determine as to what would happen to your children. And if you have left, and furthermore, if you have left any money, the courts would determine how that money is handled as well. So having a will can ensure your children are taken care of even when you are not around.
Thank you for both of your insights. So we have another question, and I've kind of merged these two questions. So if we have properties in two different provinces or two different countries, do you need to make two separate wills, or will one will in the one jurisdiction be sufficient?
I would take that. You can make one will, and that will, if you made it in Ontario, we get it probated in Ontario, and you will get what is called a certificate of appointment as a state trustee. This will be given to your executors and trustees. So this certificate is accepted by courts all over the world. Definitely in courts in India. They accept the certificate issued by the court in Ontario. So you take this certificate, you register it, say, in India, and then in India, you will proceed with getting your letters of administration. There's no need for you to go back into India to prove your will. Because when someone makes a will in India and that person passes away, the first thing is to prove the will. But if your will has been approved here in Canada, you don't need to go back to India to prove your will. Your will is already proved. Your estate trustee has got a certificate of appointment by the court, and then the court will deal with your properties in India.
Thank you. And we have one final question, and that is, after creating a will or estate plan, how often should one update it? And typically, how easy or hard is it to update a will?
It would depend upon what changes are required. I'll give you an example. A couple made their will And when they made their will, they had only 2 kids. And after some time, a third child was born. So then they came to us and said, look, this is what has happened. I had only 2 children. Now I've got another one. So we said, okay, we can always either create a new will or amend your will. It's better to create a new will, because there's another child that has to be added. So question of revising the will depend upon the circumstances and the reasons that would necessitate such a change.
Thank you. So this brings us to the end of our Q&A session. I know that I speak on behalf of everybody when I say this has been so helpful and so informative. If I was not able to ask your question, my apologies. We do, however, have a second session as part of the series. So I look forward to seeing everybody on Saturday, March 26th to hear more from our incredible speakers, Mr. Paul and Lata ji. So on behalf of everybody, I'd like to reiterate our appreciation. Thank you so much for speaking to us today. And before we end, let's do a small concluding Shanti mantra. Loka samasta sukhino bhavantu. Loka samasta sukhino bhavantu. Loka samasta sukhino bhavantu. Thank you so much, Mr. Paul and Lata ji. We look forward to seeing you all on Saturday, March 26th.
And thank you so much, Rudra, and thank you, the GTOB, for giving us this opportunity. I once again thank you, and thank my colleague Darrel Paul too, and all the listeners who have come forward today. Thank you so much, and we look forward for the next session.
Thank you, everybody.
Thank you, Rudra. You got a lovely voice. Thank you for those.
Yes, that is for certain. Yes.
Incantations.
And I have to thank Shachi and everybody from the GTOB.
Thank you so much. Thank you.
And I think people from all over the world, I think they've joined here. So I have to thank them also who have come this.